back to another episode of From Dust to Verdict. I'm your host, James Nevin, a partner at the law firm of Brayton Purcell LLP. This podcast is dedicated to the epidemic of accelerated silicosis in artificial stone countertop fabrication workers. In each episode, we explore important topics and issues about this occupational health epidemic caused by uniquely toxic artificial stone slabs, as well as the associated litigation. Today, at the start of Season 2, Episode 1, I am pleased to be joined by Liliana Carbone. Maybe we're Batman and Robin, Mario and Luigi, Woody and Buzz Lightyear, maybe Beauty and the Beast, but if anybody else calls you Beast, I'll beat them up. But Liliana is here today to talk with us about our recent verdict in the Martinez Paredes trial. Welcome, Liliana.
Hi, James. Nice to join you.
You also have the, shall we call it the honor of being our very first guest on From Dust to Verdict.
How exciting. How exciting. I do think that the listeners should know that I've been lobbying for someone to be a first guest, and I think I made it convenient for you. You said, well, if you want to guess so bad, I'll just bring you on.
Well, I appreciate you joining us today, and we have some exciting news. Why don't you tell our listeners about our recent verdict?
So at the beginning of August, a jury in Santa Monica rendered just upwards of a $47 million verdict in a wrongful death trial involving the family of Wilmer Rubin Martinez Paredes, who was a 41-year-old artificial stone countertop worker who died at that age and left behind 3 children who at the time of his death were all under the age of 14. He also left behind a wife who he'd been with for a very long time. And the jury in Santa Monica gave us a judgment on every single cause of action, finding defendants Doll Tile LLC and Doll Tile Distribution LLC, who are designers and distributors of artificial stone products, including a brand called One Quartz, liable for negligence, strict products liability, design defect, and failure to warn. The jury was completely unconvinced by the defendant's attempt to foist 100% of the blame for the harm that Mr. Martinez Paredes and his family experienced onto employers, and instead, rightly, under California law, found that these defendants were responsible for what happened to this family.
So, Liliana, this was the third verdict for plaintiffs. The first verdict was the $52 million verdict for Gustavo Reyes Gonzalez in 2024. And then several months ago, in 2026, we had the verdict in Colorado for approximately $14 million for Tyler Jordan and his wife. And now this third verdict for the Martinez Paredes family. Why do you think that jurors are rejecting the blame the employer defense and once they hear the evidence, finding for these plaintiffs?
I think there's 3 separate issues here. First, the jury is hearing evidence that the disease that we are seeing tracks a single product. The evidence has been completely uncontested by defendants that there is not a single incidence reported anywhere in the medical or scientific literature that a countertop worker working with only natural stone has died from this disease. Now, that's important because American design trends started in like the 1950s, 1960s to include granite and other natural stone countertops as a part of, what was popular in American interior design. Since the 50s and 60s, we've had shops of varying levels of sophistication, good shops, bad shops, careful and careless employers. There was no incidence of silicosis at all, not to mention advanced silicosis requiring lung transplant or causing death among these workers who only worked with natural stone, regardless of whatever shop conditions they were experiencing. all of a sudden a new product comes along and a disease tracks it exactly. So that's the first place where I think that the jurors pay attention and say, this is not the advent of a new industry. It is the advent of a new product and the inability of shops, careful, careless, good, or bad, to use the language of some, it is something that tracks the product. The other part is, I think just on like a human level, most people understand that while employers certainly have responsibilities, and Mr. Nevin and myself were extremely straightforward with the jurors in this case, and our colleagues in the previous trials have been as well, that employers certainly have duties to their employees. Employers in some of these cases may be responsible in some way for the things that they didn't do. And that doesn't take away the responsibility of a designer, distributor, or maker of a dangerous product for their part. It doesn't forgive a company. The bad actions of someone else has nothing to do with the responsibility of a multi-billion-dollar corporation knowing the dangers of its products and knowingly putting it out into the market. And then just finally, I think the evidence was actually, in our case, James, it was put forward mainly by the defense that the fact that there are unsophisticated shops out there has been well known to the industry since the 90s, when it was primarily, if not only, natural stone being worked with in these fabrication shops. And under California law and in other states as well, manufacturer distributor is responsible for the foreseeable uses of their product. And under California law, the obligation of the jury is uncontroversial. If the behavior of secondary actors is foreseeable, the original tortfeasor is responsible.
I think another important aspect of it was we heard repeatedly from the defendants that, oh, there's no such thing as artificial stone silicosis. It's just made up. The plaintiff's lawyers made this up, and natural stone and artificial stone is the same. And there's don't look behind the curtain. There's no there. And I think it was important that we were able to convey the global mainstream published peer-reviewed literature, the global findings from the health agencies such as Safe Work Australia, Cal OSHA, and actually, we weren't able to tell the jury about the findings from Safe Work Australia or the findings from Cal OSHA that artificial stone is uniquely toxic, but we were able to convey the global published peer-reviewed literature that's come to that same conclusion, most recently with the American Thoracic Society's publication last month, where they go through into great detail about this exact epidemic of artificial stone silicosis, and that this is a new and distinct and different disease, new in relative to centuries, but not new in the sense that it has been well known to the manufacturers and distributors since the first published peer-reviewed publication in 2012, that artificial stone silicosis was at that point a new disease and was going to cause disease at an epidemic level wherever it's promulgated in the marketplace. Let me ask you this, Liliana. One of the defense themes, despite the fact that there was a court order against it, we had several defense experts and defense counsel throughout the trial, all the way through closing argument, call these employers criminals, illegals, and chop shops and other, really racist and derogatory buzzwords. Do you think that had a positive or negative effect on the jury?
I think the jury could see right through it, which is slinging mud. The defendants sit on their high horse and look down on the customers that make their product valuable. As the defendants will readily admit, for example, dull tile, but take any manufacturer, designer, or distributor of these artificial stone slab products. What they sell is an unfinished slab. The commercial value comes entirely from and is only resulting from these, and it's, so far it's been almost only men who work on these products with their bodies, with their blood and sweat. This is hard work, but it's beautiful work, and it's a craft. The coworkers in this case describe the pride that they have for their job. We've heard this in other cases and from our clients throughout, that this is a beautiful job. And what you hear is what I think that the jury hears is not only the gross language, the diminishing language, trying to paint people as something other. I've heard defendants in previous trials refer to the fabrication workers at these shops and their employers as a subculture, as these people. I think that the jurors see through that. And that's because these corporations speak from a position of elitism and do truly look down on the people who make their products worthwhile to them financially. And jurors don't agree. Jurors see these men as the craftsmen that they are. The jurors understand that these are hard workers who are proud of their work, who are put in the impossible position of finding out about a deadly disease with no cure from a doctor and not from any warning label or information from the distributors and makers of these products, and being betrayed. I think there's a sense of betrayal that the jurors pick up on, which is the betrayal of loving your job and thinking, you've got a good job here. You're building LA. You're putting in the most beautiful hotel installations. And somewhere along the way, defendants started selling a product that when you cut it would kill you and didn't tell you. And now they're saying it's all your fault and that you're subhuman and that you had it coming. Defendants don't use those words, but they apply them pretty heavily. And I think the jury rejects that.
So these aren't criminal illegals and that we don't know how they got our product. These are, in fact, hardworking artists who are their customers, they intentionally set up a vast web of distribution to sell an incredible amount of their product to these less sophisticated fabrication shops, knowing that no level of OSHA controls, whether it's very low controls or very high controls, is going to actually protect these workers from getting fatal disease.
Yeah, that's right. And I think, even in previous trials, we've heard defendants kind of eat their words, saying, these are back alley fabrication shops. These people aren't responsible for installing in hotels. These are back alley workers. And in fact, the evidence comes out that they're installing all of the countertops in the Four Seasons resorts, and that many of the fabrication shops that the defendants malign are bringing an insane amount of business to these defendants because they have the national or regional contracts with various restaurants and beauty brands for the installation of countertops in their businesses. So there's the defendants try to divorce themselves as much as they can, both from the product and the process. They say, we have this thing out there. We somehow make money, and everything in between has nothing to do with us. When in fact, it is the shops that they spend the most amount of time in trial and outside in their lobbying efforts, maligning, that are bringing them the business, that are making them their money. And then they spit on them.
I think it was also important that the jury understood that not only is this what's called a vanity product, it's not, a countertop isn't necessary for national defense, but for a very long time, safe alternatives have existed, have been around for, DuPont looked at recycled glass amorphous silica back in 2006. Many of the manufacturers, with the sole exception of Cambria, already make and sell the safe, non-toxic recycled glass version. yet they still sell the uniquely toxic high crystalline silica version because they don't want to lose market share to each other. And I think that was important that the jury was able to hear that, to know that these defendants, for example, Dal Tile, who was the defendant in our verdict, they make and sell a product they call Purvana that is non-toxic. And yet they still sell one quartz, which is uniquely toxic, as the jury found. And these two products, as you showed the jury when we held up samples, are otherwise identical. They look the same. They're the same level of durability. They cost about the same. And so from a consumer point of view, the consumer doesn't know that if they pick this one, it's going to kill the worker. And if they pick this one, it's perfectly safe for the worker. They have no idea. And we were able to convey that to the jury.
Yeah, and I think there's two things from that. One, of course, there's the silica-free product, which I'll touch on in a second, but it's also all of the other natural stone products that they've always been selling. Doll Tile and then the other defendants, while they were there, with the exception of Cambria, all readily admitted and were excited to tell the jury, hey, we sell artificial stone, but we've been selling natural stone for decades. And then they put on all of these experts who stood up there and said, for example, some, tile salesman who'd run a natural stone and tile store talked about how porcelain, marble, granite, limestone can be used for all of the exact same things as artificial stone. And so we're not just, of course, since 2006, there's been an alternative to the artificial stone. They could craft this more safely. That's been around. But they also never had to sell this because they always had an alternative for consumers. The pitch for artificial stone is that it's cheaper. And there's no way to divorce the cost effectiveness, if you want to put it that way, for their high crystalline silica artificial stone from the fabrication shops and the amount of money that they do or do not have to expend in labor. I think another part of this is looking at when we're talking about the samples, we showed and maybe we can put this up on the screen somehow. We showed 4 identical samples: white marble, high crystalline silica artificial stone, 0% crystalline silica artificial stone, and porcelain. All white. They all look exactly the same for the consumer. And something that came up in this trial, and that it's so important for consumers to know, is that the consumer in choosing these products is just as blind as the fabrication shop worker and the fabrication shop owner, because the warnings are not going to be on the slabs that the consumers see. The safety data sheets, to the extent they exist, are not going to be provided by the distributor or the manufacturer to the consumer. Most consumers don't know that the difference between choosing artificial stone with high crystalline silica or marble or porcelain is the difference in someone's life, is the difference in a 41-year-old dying from silicosis or a 27-year-old getting a double lung transplant. That's a blind spot of the consumers that I think the consumers can relate to the lack of information that the fabrication workers have, because the warnings are completely non-existent to both parties. And so both the consumer in selecting their vanity, the way they're blind to the impact on the worker, so too is the worker blind to the difference in inhaling the dust or being simply around the dust. Mask, no mask, water system, no water system. They don't know that there is a serious difference between these products, same as a consumer.
Well, you mentioned warnings. I think that was also important, that what we were able to convey to the jury was that these were existing fabrication shops that had been fabricating natural stone for years. And despite the fact that natural stone does contain some amounts of crystalline silica, no worker in the world had ever been published as having been diagnosed with silicosis from it. And so these guys were working with this natural stone product for years and nobody was getting sick. Mm-hmm. And in fact, the jury heard testimony that They didn't even know what silica was. Right? They haven't even heard of silica. And then the manufacturers like Doll Tile and others come along and tell them this is pure natural quartz, talking about their highly engineered 95% content, nano-sized, high surface area, mixed with metals and resins, highly artificial product. They called it pure natural quartz. And so these fabrication shops had no reason to know there was anything hazardous. Then add to the fact that, for example, with Doll Tile, there was no warning label at all until, was it 2019?
December 2023, actually.
No warning label at all until 2023. And now, and then even when there was a warning label, it says things like not hazardous and pure and natural and all this other stuff designed to mislead them. But no warning at all whatsoever for most of the time period they were selling this highly toxic product. And then they want to say to them, oh, it's your fault. So it's your fault for believing us when we told you we were giving you a pure natural product with no warnings, telling you that, in fact, that artificial stone is so uniquely toxic that a majority of fabrication workers are going to get fatal disease from it. Imagine if the worker had seen that. In fact, as you pointed out, these manufacturers take great pains to blast their names on everything, not just in their promotional materials, in their pamphlets, on the internet, but on the back of the slabs themselves. They digitally print their names, One Quartz, or Cambria has made in the USA, an American flag. They could digitally print a huge warning label, a skull and crossbones, anything. They could convey this information so clearly to the workers, and they choose not to.
And I think that's exactly it. And I think one of the reasons this resonates with jurors is I've started to notice this when I'm on the highway. There will be construction trucks, and they carry a giant triangle with an A3 airborne hazard warning. Don't stand anywhere near this. And I've seen it, and I'm trying not to take a photo while driving 65 miles an hour on the freeway. But all of us have seen this. We know what a warning looks like. And, there's this kind of false argument from these defendants where you'll occasionally hear the attorney scoff and say, does anyone really believe that these fabricators didn't know what silicosis was? As if any of us had heard about it before these lawsuits, right? We have jurors with backgrounds in chemical engineering and mechanical engineering and have for like the last 3 years. And they almost all say, by silica, do you mean the gel packets in my purse? Some of them might think of sand, those with construction experience. The hazard is not obvious. And it is especially not obvious that even if you were to know what silica is, that the silica, the crystalline silica, its composition in the artificial stone slabs is so much different. There's so many layers to the hiding of information that I don't think the defendants can scoff their way out of it. I think that's what the jury's conclusion has been.
Well, and you mentioned scoff. I would say sort of a disdain. There was the defendants or the defense counsel really expressed throughout the trial a disdain for us, a disdain for even the judge, a disdain for definitely the coworker witnesses, for our experts. Do you think that was an effective strategy for them?
No, I don't think. I mean, just on a basic visual basis, looking at someone in a nice suit berate a coworker and friend of someone who died for 3 hours isn't really a good look. The defendants haven't found a different way of doing it in the last few trials that I've seen. I don't think they can help themselves. Their most effective punchline is calling these guys liars, or saying that the difference in a minor detail 16 years ago is somehow fatal. There's a lack of humanity in the way that the defendants choose to approach the people who work in this industry. And I don't know that I don't know how much or if at all it factors in for the jury, but as someone who works with uh, these fabrication workers daily and has since for almost 3 years now, it kind of shocks me that the companies that rely on these men seem to know so little about them and be so scared of them and so willing uh, to bully them. There seems to be no acknowledgement of the complexity of what they're going through. And I don't know that the defendants have another play.
Well, I think it's a classic example of profits over people. And, this is the result. This resulting epidemic is not a surprise to the defendants. The manufacturers and distributors of high content crystalline silica artificial stone have known now since at the latest 2012. Many of them knew before that that their uniquely toxic product was inevitably going to kill many workers, and they decided to do it anyway. And I think it's one of those things. It's like companies never learn, and if not for lawsuits like ours that force change, now we're finally forcing them to switch to safe, non-toxic recycled glass, they would just keep doing it. I mean, this is the manufacturers and distributors make around $30 billion a year selling crystalline silica artificial stone. And so it's not something that they want to just give up. And, they put a lot of effort into displacing the natural stone market. And so the hope, of course, is that we can force them, fine, keep your artificial stone, but switch to the safe one. Stop killing the workers. So when you see, again, compared to $30 billion a year, a $47 million verdict for this family is a drop in the bucket. But, do you feel like that, a verdict like that has an impact both on the defendants and on the family?
Of course it does. In different ways. The way it makes a difference for the family versus the behavior of the company is different. When you're looking at the family, ultimately, there was compensation but no justice. I think, it can be attractive to think of a high verdict as a semblance of justice, and maybe it is that, a semblance of it. But these families didn't show up looking for a check. They want their husband back and their dad's back. They didn't want any of this. I think something you see with clients over and over again is that they're overjoyed that maybe their family, their kids can go to college, that their kids are going to be okay. And it doesn't fix the loss.
One of the things, I think in closing arguments, defense counsel referred to it as something like
a lottery.
Yeah, winning a lottery.
Mm-hmm.
And as you pointed out, I think in rebuttal that they would happily give every penny back if they could have their husband and father back.
Yeah.
I mean, this is the American dream in reverse. These men and women, they come here, they work very hard, they work 6 days a week, 12 hours a day to support their family so their family can have a better life, so their kids can go to school, kids can go to college. It's what America has stood for the last several hundred years. It's what was the experience of my family. And yet now we have it in reverse where, the father can no longer provide because he's on oxygen or like in this case, dies. And, kids have to drop out of school to support the family. I mean, it's horrific.
Yeah, we've seen that. We've seen plenty, in our cases, plenty of teenagers dropping out of high school to take care of the family. I mean, and it's not just, It's not just horrible for the teenagers, it's horrible for these men are such strong guys. They see themselves as providers. And the indignity of this disease is that it not only causes a physical pain, and if someone can imagine the feeling of being underwater too long and needing air, that's what these men deal with for years. But beyond that, these are such strong guys who work every day with their hands. They are the ones who come home and fix the problems. They take their identity through their physical ability and strength. That's who they are. And now they need their kid to tie their shoes. And they can't help their wife unload the groceries. And they can't help pay. And now the kid has to drop out. The burden is unbearable. So there's a psychological and spiritual disease that I think we point to, but that's really hard to express. And it makes the money look cheap. That's why when we heard that this was, a lottery ticket, it was so offensive. And I was so glad that the family wasn't there to hear that. They weren't there for that morning, the second day of closings. And I was so glad that they didn't hear that because it was such a brazen way to erase and commodify what this family went through. I think why the defendants care so much is really these judgments provide the justice is in that these companies only know the language of money. They don't speak people. I know that Citizens United says that corporations are people. These defendants, to your point, before 2012, since 2002, I think it was, these reports started coming out of Italy and Spain. 2012 was the first big one. They've known and they've shifted continents starting epidemics, and they just move Spain, Italy, Israel, Australia, Vietnam, China, US. Let's bounce around and start epidemics until people figure it out and start finding doctors and lawyers. That's what they do. They only understand the language of money. And you can see that in what was happening in Australia. For the last few years, most of the defendants have only been selling silica-free slabs to Australia because Australia banned the product, high content crystalline silica artificial stone slabs there, because it killed so many people. And then the same company, Caesarstone, Cosentino, MSI, you name it, who are selling the silica-free products in Australia continue to sell the dangerous stuff here, knowing exactly why they can't sell it somewhere else. They only speak the language of money. And so the justice here is that $47 million means a lot to them. It means something to the family. It is important and helpful to the family. But the true justice is that you see them starting to make decisions. Daltile in December of 2023 decided to make its first warning label. Cambria and Caesarstone have started making somewhat adequate in the year of our Lord 2026 semi-adequate warning labels now. There are real changes being made, and it's only because they care about money.
So, Liliana, at this point, we have about 900 clients and counting, grows more every week. And this, I think, was our sixth trial. And so we have many, this is the sixth out of probably what will end up being a few thousand trials. And we have our next one starting in a few days. So what do you look forward to in the future of this litigation?
What do I look forward to? Well, I look forward to seeing if I think there's a few levels. One, I'm simply curious as a human if the defendants can put forward a defense that isn't totally lacking in humanity. I am curious to see how, as knowledge of the impacts of this product in this country and specifically in LA, how just the general knowledge of that affects this litigation. I am looking forward in this trial to once again asking a jury of our peers to consider the responsibility of defendant manufacturers and distributors of a uniquely toxic product and selling a product that they knew was defective and that has destroyed a man's life. And I think James and I, we were so grateful to this jury in Santa Monica. We've had such great juries. It really comes down to, if we can put the evidence in front of them, as long as we are given permission to put forward the evidence of how sick people are getting and how many, there's no other conclusion that juries can come to in these cases. And hopefully, as jurors and courts continue to render decisions to show defendants that their very expensive attempts to escape responsibility for the harm caused by their own stuff, when they see that it's not working anymore, hopefully it means that these companies start only selling the silica-free version of their product and stop litigating to death cases that we don't need a jury for this. The defendant should accept responsibility.
Well, Liliana, thank you for joining us on our first episode of season 2 of From Dust to Verdict. We're happy to have you on as a guest speaker. Looking forward to having you again in the future.
All right. Thank you.
Thank you for tuning in to this episode of From Dust to Verdict. I'm your host, James Nevin from the law firm of Brayton Purcell LLP. Remember to share, like, and subscribe. Stay tuned for our next episode, where we will continue our discussion of the silicosis epidemic caused by uniquely toxic crystalline silica artificial stone, as well as the associated regulation and litigation. Para todos los que hablan español, les recomiendo que escuchen la versión en español de este podcast, presentado por mi buen amigo, Charlie Velasco Ariza.
This podcast contains subjective commentary and opinion-free speech intended to provoke thought and discussion. Investigative commentary intended to shed light on matters of public interest to inform the audience and encourage civic engagement, accountability, and transparency. Findings that are a result of diligent research, fact-checking, and analysis of publicly available material, including news reports, public records, interviews, personal research, experiences, published peer-reviewed medical and scientific literature, published governmental health authority regulations and findings, and other accessible sources. Any conclusions drawn reflect the creator's interpretation of that information and are presented in good faith, and are not intended to malign, defame, or harm the reputation of any individual, group, company, or entity, but rather are intended to be allegations acknowledged to be disputed by artificial stone slab manufacturers and suppliers. The speech herein is protected under the First Amendment of the U.S. Constitution. Litigation privilege, CA-CC 47B. Fair reporting privilege, CA-CC 47D1. Anti-SLAPP, CCP 425.16. And fair use doctrine, Section 107 of the Copyright Act of 1976. This podcast and all content herein are exclusive property of Brayton Purcell LLP and are protected under applicable copyright and trademark laws. Unauthorized use, reproduction, distribution, or exploitation of this content in whole or in part without express written permission is strictly prohibited. All rights reserved.